Welcome. In this video, we'll break down the essentials of the Debt Recovery Tribunal Act, a key law that streamlines the process for banks and financial institutions to recover debts in India. We'll explore who it applies to, how the tribunals work, and the step-by-step procedures involved. Whether you're a student, professional, or just curious about financial laws, this guide will help you understand the structure, powers, and practical impact of the DRT system. Let's start by looking at the scope and application of the Act and why it was introduced to address the growing problem of unpaid bank loans. Debt Recovery Tribunal Act extends to the whole of India. It came into force on June 24, 1993, marking a significant step in banking law. However, not every debt falls under its purview. The Act applies only if the debt owed to a bank or financial institution is at least 20 lakh rupees. The central government can specify a lower minimum, but it cannot go below 1 lakh rupees. This ensures that only substantial cases are brought before the tribunal, keeping the system efficient and focused on larger defaults. The Act defines bank broadly to include not just traditional banking companies, but also corresponding new banks, the State Bank of India, its subsidiaries, regional rural banks, and multi-state cooperative banks. This wide definition ensures that all major banking entities can utilize the tribunal system for debt recovery. By covering a range of institutions, the law aims to provide a uniform mechanism for resolving debt disputes and strengthening the financial sector's ability to recover dues. Under the Act, debt means any legally recoverable amount owed to a bank or financial institution, including interest. It covers money due in cash or any other form, whether secured or unsecured. Debts can arise from loan agreements, court decrees, arbitration awards, mortgages, or even assigned debts. Importantly, the debt must exist and be legally recoverable on the date the application is filed. This ensures that only genuine, enforceable claims are brought before the tribunal. Debt securities are financial instruments like bonds, debentures, and notes that represent borrowed money. To fall under the Act, these must be listed on a recognized stock exchange and regulated by the Securities and Exchange Board of India (SEBI). This ensures transparency and investor protection. In short, debt securities are borrowing instruments that are strictly regulated, making them a safer option for both lenders and investors. Financial lease is a long-term rental of a tangible asset, such as machinery or vehicles, where the lessee makes fixed payments and eventually gains ownership, either at the end of the lease or by paying a pre-agreed amount. The asset itself is not negotiable, and the arrangement is designed so that the lessee ultimately becomes the owner. This concept is important because financial leases can also be the subject of debt recovery proceedings under the Act. Act gives a very broad meaning to property. It includes immovable property like land and buildings, movable property such as goods, machinery, and vehicles, as well as debts or rights to receive money. Even intangible assets like know-how, patents, copyrights, trademarks, licenses, and franchises are covered. This wide definition ensures that banks and financial institutions can recover their dues from a variety of assets, not just physical ones. Security interest is any legal right or claim over property given to a bank or financial institution to secure repayment of a loan. This can include mortgages, charges, hypothecation, or assignment. It covers both tangible assets like machinery and vehicles, and intangible assets such as patents or licenses. The security interest ensures that the lender has a fallback in case the borrower defaults, making lending less risky. Central government is responsible for setting up debts recovery tribunals, DRTs, by official notification. Depending on the need, one or more DRTs and benches can be established across the country. Each DRT has a defined territorial jurisdiction, meaning it handles cases from specific areas. These tribunals exercise powers under the DRT Act and also act as adjudicating authorities under the Insolvency and Bankruptcy Code, 2016. Each debts recovery tribunal is composed of a single member, known as the presiding officer. This person is appointed by the central government. In some cases, a presiding officer or judicial member from another tribunal may also be authorized to act as the DRT presiding officer. This streamlined structure helps ensure quick and focused decision-making in debt recovery cases. To be appointed as the presiding officer of a debts recovery tribunal, a person must be, or have been, or be qualified to be a district judge. This ensures that only individuals with significant legal experience and expertise are entrusted with the responsibility of adjudicating complex debt recovery matters. The presiding officer of the Debts Recovery Tribunal holds office for a term of 5 years and is eligible for reappointment. However, there is a maximum age limit of 65 years. This term structure ensures both continuity and the opportunity for fresh appointments, maintaining the tribunal's effectiveness. Presiding officers appointed after the Tribunal Reforms Act, 2021 are governed by the new Act for their qualifications, appointment, tenure, salary, and removal. Those appointed before the Finance Act, 2017 continue under the original DRT Act and its rules. This dual system ensures a smooth transition and clarity in service conditions for all officers. The central government provides the Debts Recovery Tribunal with recovery officers and other staff. All staff work under the supervision of the presiding officer, and their salaries and service conditions are set by rules. This support structure ensures the tribunal can function smoothly and efficiently. Central government also establishes the Debts Recovery Appellate Tribunal (DRAT) by notification. The DRAT hears appeals against orders of the DRT and also appeals under the Insolvency and Bankruptcy Code, 2016. The government specifies which DRTs fall under each DRAT, ensuring a clear appellate structure. The Debts Recovery Appellate Tribunal (DRAT) consists of only one member, known as the chairperson, the chairperson is appointed by the central government through official notification. This single-member structure helps in quick and focused disposal of appeals. Be appointed as chairperson of the DRAT, a person must be or have been qualified to be a high court judge or have served in the Indian Legal Service grade I for at least 3 years or have worked as a presiding officer of a tribunal for at least 3 years. This ensures that only highly experienced legal professionals lead the appellate tribunal. The chairperson of the Debts Recovery Appellate Tribunal holds office for 5 years and is eligible for reappointment. The maximum age limit for the chairperson is 70 years. This arrangement ensures both stability and the possibility of bringing in new leadership when needed. The staff provisions for the Debts Recovery Appellate Tribunal are similar to those for the DRT. The central government provides staff who work under the chairperson. However, recovery officer provisions do not apply to the appellate tribunal. All service conditions are prescribed by rules ensuring smooth functioning. Salary, allowances and service conditions, including pension and retirement benefits, of the presiding officer of the DRT and the chairperson of the DRAT are prescribed by rules. Importantly, these terms cannot be changed to their disadvantage after appointment, ensuring security and independence for tribunal members. If the post of presiding officer of the DRT or chairperson of the DRAT becomes vacant, the central government appoints a replacement. Ongoing cases continue from the same stage after the vacancy is filled, ensuring that the tribunal's work is not disrupted. Presiding officers and chairpersons may resign by giving written notice to the central government, but must continue for 3 months or until a successor joins unless allowed to leave earlier. Removal is only for proven misbehavior or incapacity, following an inquiry by a High Court or Supreme Court judge. Suspension during inquiry is possible and the right to be heard is mandatory. Detailed procedures are set by rules. Chairpersons of the DRAT appointed after the Tribunal Reforms Act, 2021 are governed by the new Act for qualifications, appointment, tenure, salary and removal. Those appointed before the Finance Act, 2017 continue under the original DRT Act. This ensures clarity and consistency in service conditions. Appointment orders for the presiding officer of the DRT or chairperson of the DRAT cannot be challenged. Even if there is a defect in the tribunal's constitution, its proceedings and orders remain valid. This provision ensures that technicalities do not derail the debt recovery process. DRT decides applications for recovery of debts by banks and financial institutions and also acts under the Insolvency and Bankruptcy Code 2016. It can hold circuit sittings at district headquarters. The DRAT hears appeals against DRT orders and also appeals under the IBC. This dual role strengthens the debt recovery framework. Chairperson of the DRAT has superintendence and control over DRTs under his jurisdiction. He can call for case statistics, review performance, hold meetings, and recommend inquiries into misbehavior or incapacity of presiding officers. The chairperson can also transfer cases between DRTs after giving notice and hearing to parties. On the appointed day, only DRTs and DRATs can deal with matters under Section 17. Civil courts and other authorities are barred, except for the Supreme Court and High Courts under Articles 226 and 227 of the Constitution. Pending recovery cases of multi-state cooperative banks under their own act continue unaffected. Banks or financial institutions can apply to the DRT for debt recovery. Applications can be filed where the loan account is maintained, where the defendant resides or works, or where the cause of action arose. The application must be in the prescribed form with true copies of documents and the prescribed fee. Banks must disclose secured assets and their estimated value, and if insufficient, other assets of the defendant. DRT issues summons to the defendant, directing them to show cause within 30 days, disclose assets, and not dispose of assets during proceedings. Defendants cannot transfer secured assets without DRT's permission. These measures prevent borrowers from hiding or disposing of assets to avoid repayment. The defendant must file a written statement within 30 days, extendable by 15 days. They may raise a set-off adjustment of amounts due or counterclaim treated like a cross-suit. All pleadings must be supported by affidavit, ensuring that only genuine defenses are raised. The DRT has wide interim powers. It can order attachment before judgment, restrain disposal of property, appoint a receiver or commissioner, and even detain the defaulter in civil prison for noncompliance. These powers help ensure that the recovery process is not frustrated by evasive tactics. After hearing both parties, the DRT passes an interim or final order and issues a recovery certificate to the recovery officer. This certificate is treated like a court decree for insolvency or winding up proceedings. Sale proceeds of secured assets are distributed as per IBC priority where applicable. The Act encourages speedy proceedings, ideally to be completed within 180 days. The DRT may pass any order necessary to give effect to its decisions, prevent abuse of process, or secure the ends of justice. This focus on efficiency ensures that debt recovery is not delayed unnecessarily. Central government may allow electronic filing before the DRT and DRAT. Applications, written statements, and documents can be filed online with digital signatures. Summons and notices may also be served electronically, and orders uploaded on the tribunal's website are treated as public notice. E-filing may be made mandatory or optional, as prescribed. Any person aggrieved by a DRT order can appeal to the DRAT, except for orders passed with consent of parties. Appeals must be filed within 30 days, though delays may be condoned for sufficient cause. The DRAT may confirm, modify, or set aside the DRT order after hearing both parties. Appeals should be disposed of quickly, preferably within 6 months. A borrower appealing to the DRAT must deposit 50% of the debt amount decided by the DRT. The DRAT may reduce this deposit but not below 25% by recording reasons in writing. Without this deposit, the appeal will not be entertained, ensuring only serious appeals are filed. The DRT and DRAT are not bound by the Civil Procedure Code. They follow principles of natural justice and can frame their own procedure. They have civil court-like powers such as summoning witnesses, calling for documents, taking evidence on affidavit, and reviewing orders. Proceedings are treated as judicial proceedings. The central government may prescribe uniform rules for conducting proceedings before the DRT and DRAT. These rules must be consistent with the Act, ensuring fairness and consistency across all tribunals. Banks and financial institutions may appear before the DRT or DRAT through lawyers or their own officers as presenting officers. Defendants may appear personally or be represented by lawyers or authorized officers. This flexibility ensures parties can choose the best representation for their case. The Limitation Act, 1963 applies to applications filed before the DRT. This means claims must be filed within the prescribed limitation period, ensuring that only timely claims are entertained and old, stale claims are avoided. After receiving the recovery certificate, the recovery officer can recover the debt by attaching and selling the borrower's property, taking possession of secured property, arrest and detention, appointing a receiver, or any other method prescribed by the central government. This wide range of options ensures effective recovery. The amount mentioned in the recovery certificate cannot be challenged before the recovery officer. However, the presiding officer of the DRT can withdraw the certificate or correct clerical or calculation mistakes. Any such changes must be informed to the recovery officer. Even after a recovery certificate is issued, the presiding officer may grant time to pay if the defendant pays at least 25% upfront and gives an unconditional undertaking for the balance. During this period, recovery proceedings are stayed. If the defendant defaults, the stay ends automatically and recovery resumes. The recovery officer can use additional methods such as garnishee proceedings, directing third parties to pay amounts owed to the defendant, deduction of money payable to the defendant, attachment of joint accounts, and even distraint and sale of movable property. These powers make recovery more comprehensive and effective. The Act includes several important miscellaneous provisions. All pending debt recovery cases are transferred to the DRT on its establishment. Secured creditors have first priority to recover dues by selling secured assets. Tribunal members and staff are deemed public servants, and actions taken in good faith are protected from legal action. The Act overrides inconsistent laws, and the central government can make rules and remove difficulties as needed. Finally, the earlier ordinance is repealed, but actions under it remain valid.